to call the Committee of the Whole meeting for September 12th to order. Please call the roll.
Alderman Strelchuk is absent. Alderman Telako? Alderman Meyer? Here. Alderman Hancher?
Here.
Alderman Bach?
Here.
Alderman Parrish?
Here.
Alderman Schneider?
Here.
Alderman Gebhardt?
Here.
And Mayor Nurbin.
Here. First up, we have the meeting minutes from August 8th.
Move approval.
Second.
Motion and a second. Any comments, corrections? Hearing and seeing none. All those in favor, please say aye.
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 Any opposed? And the minutes are approved. Next, we have a discussion on a review and discussion regarding the proposed amendments to Chapter 62 of the Mequon Municipal Code for the sign code. And our city attorney is going to give us an overview and a bit of a history lesson.
Certainly, thank you. Good evening, Council. Just to kind of give you a little signpost, if you will, as to where we're going, pun intended in this case. We're going to talk a little bit, just very quickly, about some of the history, how we got here. We're going to talk a little bit more in depth of some of the legal issues that we're facing and that are involved in the process. Then we're going to dive right in to talk about some of the changes that are being proposed within the sign code itself. And then lastly, to wrap it up with some policy input and discussion from the council in terms of where we're at. So in terms of history, really it ended up being a little bit of a perfect storm. We had kind of a combination of a number of things that ended up causing a number of concerns for us. We had some significant changes in case law. There's the Pewaukee case there that really dealt with political signs, campaign signs, really basically says that you can't regulate those at all in any real meaningful way. The Reed case is kind of preeminent case recently that really turned First Amendment law, at least as it related to government regulation of First Amendment, kind of on its ear, and we're going to talk a little bit about that when we get to the legal section. In addition to that, we had kind of political firestorms all over. We went from recall elections to school board referendums to Trump and Biden and signs related to that, and complaints all over the place about, this sign is offensive or not offensive, or they've got too many, or whatever the case may be. We also had some statutory pressures that ended up coming to bear. The legislature made some changes in what they called the developers bill that changed some of the regulations that we have as it related to some development signage. And then lastly, and as part of that referendum process, we did receive a threat that an entity, an individual, was going to sue us because of our regulations as it related to signs on public property and in the right-of-way. And so all of that caused us to effectively kind of call a little bit of a timeout. We immediately jumped on the regulation of signs within the right-of-way and public property. A number of you were on the council at that time, although I think we've got, 4 of you that maybe are new and weren't really necessarily part of that process, although at least one of you was on Plan Commission when it went through there. So at least a little bit of history there. That section, when we adopted it, was really adopted as its own section, intended to stand completely on its own until we were able to go through the full process. And as you'll see when we get into the legal background, one of the concerns that we had moving forward was how the Reed case was going to impact things like how we dealt with commercial signage. If the Reed case ended up being applied to commercial signage in the way that we all feared, it would have required a significant update to the code. Things that we currently regulate and historically have regulated would just not be possible anymore. Little preview, as we'll see, thankfully we didn't have to go that far. The Supreme Court and the Seventh Circuit did preserve a lot of our regulatory rights with respect to commercial signage, so the task did not need to be nearly as monumental as it could have been. With respect to kind of the legal background, I think all of us are kind of familiar with the saying that you can't yell fire in a movie theater. That there are some regulations that obviously can be imposed upon free speech. That, in the best case scenario, is a situation that the courts basically apply what they call intermediate scrutiny. Intermediate scrutiny it basically deals with the circumstance where you have a content neutral regulation that is narrowly tailored to a governmental interest, and that you have ample alternatives or channels for speech to otherwise take place. Content neutral generally is the things that we call time, place, and manner. The times that you're regulating speech, the locations of speech, the manner in most cases that speech is made. What is not content neutral is where you're actually picking winners in a sense. That you would say that we would allow, for example, a pro-recall sign but deny anti-recall signs in a particular location. Likewise, types of speech a lot of times can be part of that too. There's a case, for example, out of the DC area where District of Columbia had passed a regulation that said that you can't, in a sign, say bad things about other countries. That basically other countries were offended that we would say bad things about them in front of their embassies and that kind of stuff. And they passed a regulation to try to calm the waves. And the court said, nope, that type of speech regulation isn't appropriate as well. So the Reed case, as I said, really kind of turned what we knew on its ear. Before Reed, we typically were able to regulate messages that were content-based, provided that we weren't discriminatory towards any certain particular message. So in other words, as long as you were not picking winners, that a lot of what otherwise were considered to be content-based type distinctions were permissible. So for example, you could do a regulation that would say, you can have a real estate sign in front of your house for only 3 months, and then after that you have to take the real estate sign down. That is a clear regulation that's based on the content, a sign that is based for real estate, but those types of things were otherwise allowed. What Reed basically did is said, no, you guys have this all wrong, that the First Amendment actually protects those circumstances where you are regulating that content-based distinction. Effectively what they say in short, as we say on the slide, that if you have to look at the message on the sign to determine what type of sign it is, that in and of itself is a content-based distinction, and that runs afoul of the First Amendment. Clearly a change from the historical perspective that had taken place. And as I said, there were a number of impacts to that. Traditional regulations that we had became questionable. Regulation of real estate signs, regulation of rummage sale signs, political campaign signs, although that really had, at least locally, been taken care of by that Pewaukee case that I mentioned earlier. But on a nationwide level, that certainly applies. All of those are now controlled by what the courts call strict scrutiny, which says that you have to have a compelling or a very strong interest in regulating whatever the content that you're looking to regulate. It also has to be very narrowly tailored. You have to pinpoint exactly what you're talking about. You can't have a broad-based regulation that just happens to impact a particular area of speech. And then the piece that's virtually impossible to meet from a government's perspective is that it has to be the least restrictive means in order for you to regulate that content. The courts basically, there's very few instances where the courts have said this is a least restrictive type circumstance, and so it becomes very difficult. As I kind of previewed a moment ago, the biggest unknown for us, though, was how Reed really impacted commercial signs. and the regulation of that. Historically, commercial signs had been afforded that intermediate scrutiny that we talked about, even though it was clearly a content-based distinction. I mean, nobody doubted that as it related to commercial signs, but they were nonetheless afforded the intermediate scrutiny, primarily because commercial signage, in the court's view, does tend to be different. There's a greater possibility of misrepresentations that take place. There is far greater possibilities that you're going to have excessive signage in locations that creates distractions for roadways, those types of concerns. And so the courts have generally applied that intermediate scrutiny to it. Obviously, if Reed came into play and said, nope, we mean it, all of that went out the window in terms of what was going on. And so it caused us to really kind of pause a little bit, because there were 4 different First Amendment commercial regulation lawsuits that were pending in the various courts throughout the country, including a court case out of Madison that was in the Seventh Circuit Court of Appeals at the federal level, and then also a case that was out of Austin that was in the Supreme Court docket for consideration. And so wanted to see how those kind of played out before we made any significant determinations of how to deal with things. Ultimately, those cases saved the day for us. Both the Seventh Circuit and the U.S. Supreme Court, in those 2 cases I just mentioned, ultimately did say, no, nothing has changed. Commercial regulations continue to be subject to that intermediate level of scrutiny, and things kind of go on from there. So with that in mind, we drafted a number of code updates that were in the packet. As I kind of indicate in the memo, the idea for this evening is just to kind of give you the broad-based, high-level, here's what we're thinking. Some of the more detailed things will come at a future point. We'll go through the Planning Commission process and deal with, there are a number of policy-related issues that staff have identified that we'd like to update. If we're going to touch the sign code, we might as well touch it and cover all of it. We didn't include that as part of this process because we wanted to make sure that we were identifying, here's the changes that we really need to be compliant with Reed and the Seventh Circuit and the U.S. Supreme Court on the commercial signage, and then to deal with the policy issues coming forward. And so, as I highlighted earlier, one of the conclusions of this discussion will be just to kind of get some input on some policy issues that we are aware of, and then just to see if there's anything else that has concerns for you folks. So as we go specifically to the proposed language, in the initial part, and you'll see on the slide here, I try to reference where in the packet page it starts. So the page number is the packet page for the benefit of all of you if you want to look at it and follow along. But effectively in the findings, the purpose, and the definitions, we really greatly expanded and clarified the findings in the purpose section. These sections really become critical if we were to get challenged because as we've just talked about, both intermediate and strict scrutiny do ultimately consider the purpose of the regulation. What are we regulating? Why are we regulating? And how are we attempting to do that? And so those findings and that purpose really help us to define those purposes in a way that is consistent with other cases where the regulations have been upheld. And so we tried to take that into account as we expanded the various purposes and findings that we identify. With respect to the definitions, the biggest change is just that we combined all of the definitions into one section. We had a couple instances of sections of the code where we had specific definitions within that. We just put it all in one section just to make it consistent. And then we went through and we eliminated any of the content-based definitions that were present. So for example, we used to have a definition for a real estate sign. We don't need that anymore because we don't specifically regulate real estate signs. So we get rid of all of those content-based distinctions that are there as part of that definition process. Moving on, in the permits section, the prohibited signs section, and the exemptions section, the permits, there wasn't a whole lot of change there. We really just clarified and streamlined the code language just to make it a little bit more clear about how that process works. With respect to the prohibited signs and the exemptions, significant changes in these locations, especially as it relates to the exemptions. In a lot of cases, the provisions that were in the existing code were consolidated with other sections. So, for example, sub 22 there in the prohibited signs deals with regulations of signs within public right-of-way and on public property. Obviously, that's all part of the regulations that we just adopted last year as it related to public property and right-of-way signs. And so we didn't need to have them in both locations, so we eliminated it or consolidated it. We also eliminated specific content-based language again. We did clarify and eliminate certain problematic language, things that from a regulatory standpoint maybe are not necessarily an issue with Reed, for example, but things that just created problems for us as we look to enforce. So one example of that is we had a code provision that said that you can't have a sign that contained a misstatement or an untrue statement. Never in my life would I have figured that that would have been a problem. Obviously, over the last couple of years with COVID and all of the politics that have associated with it, what we used to think was an objective fact sometimes doesn't appear to be. And we had individuals that would point to that provision and say, you need to force them to take that sign down because it's not true. It's just a fight that we don't need to have. And so we eliminated that type of language as part of the process. And then lastly, we did add one exemption to the exemption list. We took a whole bunch out, but we did add one, basically for signs that are allowed by other laws. That language was really designed specifically to deal with that developers bill that we just talked about, where they said that developers basically can put a construction sign all the way around the fence of their property, and there's no regulations that we can have to deal with that as part of it. So we just exempt those types of restrictions, primarily because I'm not sure that the state under Reed can even make that distinction, but that's not our fight to have. That's ultimately the state's fight to have. So that's part of that. Another area where we saw some significant changes is basically how we deal with permitted signs in general. We basically split it into three sections: signs that are related to residential properties and residential areas, signs that are related to public property and right-of-way, and then signs that are related to commercial properties. With respect to the residential areas, we really stepped back from most regulations there. Almost everything that we regulated in residential areas was a content-based distinction. Real estate signs, political campaign signs, all of those types of signs that were part of it. And so we really stepped back from that type of regulation, and we make our limitations purely that time, place, and manner restrictions. That you can have temporary signs. The code talks about that being up to 4 months, although how you regulate whether it's been there 4 months or 5 months is a little bit difficult. So realistically, it's more of the intent of the sign as opposed to how long the sign has actually been there. But the primary thing is that you can have a maximum of 15 square feet of signage. That can be one big sign of 15 square feet, or it can be a number of smaller signs that amount to a total of 15 feet, and no one sign can exceed the height of 4 feet. That language actually did go through public welfare in the fall. We did start talking about that, and that really came out of the public welfare committee's recommendations based on what they felt they were comfortable with. We do in residential areas have some commercial or directional type signage that we continue to allow, building names or addresses, subdivision monuments, and then the provisions of home occupations. None of those code regulations changed from the existing. We just put them within the residential area to just clarify the process. public property and right-of-way, there we really just integrated it in the full code. As I mentioned before, we had adopted it separately to keep it separate while we were working on the rest of it. Now that we've touched the rest of it, we've just integrated it within the full code as part of that. For non-residential areas, we made a couple changes. First, we incorporated sections that were kind of freestanding otherwise. So we incorporated, for example, the freestanding section that dealt with signs facing I-43. As well as a freestanding section that dealt with some agricultural farm signs, and we just incorporated those into that section. No significant changes to those provisions itself, other than just the incorporation into the non-residential section. We likewise removed a lot of the content-based language that was there. For example, there's a provision that talks specifically about religious signs. That would be a big red flag under read, and that's not commercial speech per se. And so all of those regulations we took out of the religious context and instead just classified them for all properties in the IPS zoning district, the institutional and park district, basically, as part of that. Likewise, special event signs become a little bit problematic because it may or may not be commercial, so we just generally put those in a category that classified them as general temporary signs, and some regulations that related to that. And then the last thing that we did do is I did address one policy issue that I knew existed, and that dealt with a circumstance where we had a proposal where there was a building that had basically a wall of windows. And there was a question under the code about whether or not the code, which allowed up to 25% of the window area to be covered, if that meant the individual windows or the whole wall of windows effectively. And we did clarify that to say that it's the individual windows that we count, and that you can't take advantage of 25% in multiple windows to make a bigger picture or bigger sign. That's part of that. So we did address that one policy issue that was part of that. So with that, talk just very briefly about some policy input and discussion. In terms of the policy input, I kind of highlighted a little bit of this in the memo in terms of the where we go. The first is in the public property section. We did retain, those of you who were on the council at the time, this concept of the blue kind of directional signs. We have a number of these historically within the community that it's basically a sign that says, the country club is this way, or the gun range is that way, or the church is over here. Those types of signs. At the time that we adopted it, there was significant concern on certainly my part, and I think some of the council members about, hey, does this maybe create a distinction of content base that maybe becomes problematic? I'm not here to say whether or not we want to change that for sure or not. What I can tell you is that we haven't had anybody apply for one yet. So there's not a whole lot of individual.
Well, we've had the renewal for those that we notified were going to be taken down.
Right.
So no new ones.
No new ones. There are the handful that we knew existed that have done. For example, the gun range on the southwest corner of the city did go through that renewal process for their sign, but we haven't had any new applications for additional signs in any locations. Likewise, within the commercial signage section of the code, we do make a couple distinctions that are not necessarily based on its location within a commercial district, for example, but specify specific uses. For theaters and concert halls, for example, we authorize them to have a marquee sign, which kind of makes sense. I mean, a theater without a marquee sign is kind of silly, but it is a distinction that doesn't appear to be necessarily, rooted in any particular reason why we're looking to regulate things. Likewise, with gas stations, within the electronic sign section, we allow gas stations to have signs that have prices that change. Again, makes sense. Be kind of silly to have a gas station without a sign that advertise prices. It's kind of what they do, but it is potentially a distinction that might run afoul of the Reed case. And then lastly, with restaurants, we talk about sidewalk signs or sandwich boards. Again, why does a restaurant get those types of signs versus some other particular type of commercial use within an area? So I think at least with respect to the commercial signage, you have a couple options. The first would be you just don't allow those distinctions at all, and you just don't allow them. The other option would be to just open it up broader to say everything within that commercial district is able to use those. Or the third one is that you could tie it to a specific zoning district. And I think that at least my recommendation for those is that for marquee signs, I think you just do away with that regulation altogether. I don't think that theaters, concert halls, it's not a big use that we have here. Certainly a marquee sign, is helpful maybe on State Street in Madison where you're walking under it and, oh, there's the sign. I think probably most people that go to a theater or a concert hall here in Mequon probably know what's there and aren't drawn in by the fact that there's a sign. So I would get rid of that one. Gas station signs, I think that's one that in my recommendation, you just roll the dice on. There is maybe a little bit of risk that's an unfair classification. I just don't know of another good way to deal with that. It's such a specific use, and it's really more of an informational sign, a directional sign, if you will, than anything. And I don't have a great way of doing it, and so I think you leave that one in place. And then as it relates to sidewalk signs and sandwich boards, there I think you use that last option. You tie it to specific zoning districts. For example, you might allow them more, and I may get yelled at by Kim behind me here, but maybe you allow it more in the town center district where it's more walkable, and you don't allow them in places like along Port Washington Road where it's maybe not as walkable, or maybe you flip that, depending on the purposes. But I think you could allow a broader range of potential users to have those types of signs, but you just key it into specific locations that you might want to do it. And that's where we're at. So those would be the areas that we're looking for specific input at this point. And then, as I said, if there are other areas that the council does, there's signs that have concerned you about, hey, why do we allow those, or just general concerns about signs in general, we can certainly talk about those. And then, as I say, those will be put together, packaged with the other greater policy discussions that will then be taken to Plan Commission and then ultimately come back to the council for approval, likely in the November, December timeframe is what we're looking at.
Thank you. I think we'll open it up for some questions and comment. Does anyone have any reaction they'd like to share with City Attorney? I know it's a lot to digest, especially if you weren't here a couple of years ago for round one. I'm not seeing any takers. At the risk of thinking out loud here, for some of those outliers in the commercial districts, would it be another way to handle that, to put them in a bucket and say you need a master sign plan for a site, so there's still some ability to exercise control without prohibiting them but not letting it go wide open either? And I realize you may not have an answer for that because I just surprised you with that. And certainly this we're not taking any final action here tonight. This goes to Planning Commission and will come back to us, so there's time to catch up with it.
It's certainly a good idea, one that I'll contemplate in light of some of the case law, but that may be a good solution, actually.
Okay, I'm just thinking of ways to
spitballing on
not
the top of
totally
my head
prohibit
as well,
things, but give some level of control, so it just doesn't. I think what no one wants is for signs to just explode because we stopped regulating it at all. But in some instances, if we were to tell the gas stations you got to get rid of your signs, there'd probably be some sort of revolt, rightfully so, there as well.
And certainly the other thing that I will offer, recognizing that those of you who are on the council went through a lot of discussion. I mean, this was a multiple meeting thing that we went through. You new folks, you're just kind of getting it all at once. You know, if as you've reviewed this, or even as you look at it after the discussion this evening, if you do have questions, concerns, just you're not understanding something, feel free to reach out to me. I'm happy to work through any questions or issues that you might have as well.
Alderman Meyer.
Yeah, and in 6218, that language sign plan as a whole, individual specific signs within it. Correct. Now, obviously, I mean, you may object to the whole sign plan because of an individual sign, you know, which would certainly be one of the reasons why you could look to confirm that master sign plan. But the idea would be that it's the whole plan that we're reviewing, not you couldn't object to just one specific sign individually and say everything else is okay. You'd no, I think, and Ms. Tollefson can correct me if I get this wrong. I mean, it's historically been used in the same way that we confirm some other actions of the Plan Commission, where they grant an approval that is basically notice to the council that, hey, we've taken this action, and then the two members of the council can say, hey, I don't know that we agree with that. Let's have the council look at that before we formally grant that approval. So.
The sign comes through the planning commission and two council members don't agree with that, they can bring that up.
Well, a sign plan. Sign plan is a specific.
Their plan for the sign, for a business that's going in.
Right. The master sign plan is a broader based where you have, you know, so for example, Concordia, where you have signs all over the property, has a master sign plan to deal with all of the various different signs on the property.
So they have a master sign plan for their, the same thing as that if there's a big business comes in, must have a master sign plan. So that's what you're saying.
Right.
It's kind of the same thing as saying it's an individual one that comes through on it, but it's also, does it depend upon just the plan itself, or does it have to be with a waiver that's granted inside of it for us to bring it up?
This language would relate only to those master sign plan approvals, not so like if there was just a waiver that was granted to a sign, or the plan commission approved a particular sign outside of the master sign plan process, that would not be covered by this. It would only be where the plan commission has granted an approval for a master sign plan, the full plan itself.
Isn't that kind of upside down? I mean, because normally if you had a master sign plan that was all in accordance with the sign code, there would really be no grounds for aldermen to bring that back then. It'd only be if there was a waiver to that sign code that they granted in that master plan. And then that would be the basis for the alderman to come back in, because it'd be a waiver from the approved sign code.
I think we're effectively saying the same thing. I mean, typically you would get a master sign plan for a property where you are looking to deviate from the regulations that otherwise might apply in terms of, total number of signs or locations, those
I was
types
gonna
of
say that's
concerns.
where we tend to use those.
Right.
Is where you,
So
the
it's-
the total impact of the totality of the total number of signs would exceed normal code provisions, but where it actually might make sense for a larger campus like a Concordia, or maybe the pavilions and everything that's going on within that development.
Right. So it's kind of the same thing, but it wouldn't apply to, just a single sign that, the business put out, the monument sign that the new building put out in front just by itself. That's not contemplated by this, even if there was some waiver that was granted to that. It's really that bigger picture master sign plan that's part of that process.
So do you think it's important that the common council should be able to, if there's a single monument sign that's put inside that's contrary to the sign code because the planning commission grants a waiver to it for reasons, that we should not be able to take a look at that? Especially since if we have
That's for us to decide.
residents inside that area are in protest of that?
Well, what I can tell you is that we can certainly include that as one of the policy discussions of how broad we want to make this kind of review approval apply, and include that as part of that process.
Okay. I had just one other one inside of this,
Go
a
ahead,
short
yeah.
little note. It was the old 62-16, it's now 62-14A2. And it just had to do with the time frame for a repair on a sign. It was giving the person 60 days inside of that. I don't know what the common council goes with, but I think 60 days is to repair a sign is a pretty long period of time, and that should be dropped down to, about 30 days for once they get notification. So we can have something that's in total disrepair for, 60 days instead of having them take care of it right away.
Yeah, I think we could address something related to that. I mean, I think there may be some signs that if they're particularly complex, wall sign, for example, might require more time because you need to fabricate a new part or something like that. But I think we can address that within this language, that at a minimum, we need to have the specific plan for how you're
Yeah,
going
maybe
to
just have a
address
plan in place so that,
Yeah.
by 30 days to do it.
Yeah.
All right, Alderman Parrish.
Thank you, Mayor. Thank you, Attorney Sajak. I hope former Mayor Worth is watching all this. He would have absolutely just eaten this conversation up, as you know. So,
I fully expect to get a call from him
yeah,
after
you will.
this evening.
You will,
so.
and he may have some good comments as well. I did find it I like to prepare and read all this stuff, and I did find this a little more difficult to prepare for, and would appreciate a red line. Just after this meeting, it would be a little easier. I know it would be like Swiss cheese was your point in the memo, but it is hard to figure all this out. My district is along District 6, which has most of the west side of Port Washington Road essentially is all in my district. So I am getting notifications at least minimum once per week of some business getting written up. So hopefully part of your recommendations analyzed all the fines and all the staff time trying to administer the current code, and maybe identify where things are taking, there's certain things that are being written up over and over again that I'm seeing. I'm thinking specifically a couple of things. One, in a multi-tenant building where each one of those businesses wants a little sandwich board sign about their little sale going on or what have you. And I read this to be one of those per property. So if you wouldn't mind, you don't need to answer that today, but just please speak to Director Tollefson and make sure we're not setting up something that's impossible to administer as well.
I can tell you that kind of concern is one that we've talked about as we've gone into this process, and it is one of the policy areas that we do intend to look at and see if we can address. So
Yeah, and then those marquee signs where it's like a they blow in the wind and it's tall and it angles over. All the businesses love those, and they get written up like immediately, I think, for those. And so I get a lot of complaints about that. So that's really my comment. That's actually the gist of I think the things we do. And then I noticed that we have a provision in here for the library, and I guess I was surprised that we're carving out the library, and I guess hope that Director Mushin can weigh in that with you at a later date and make sure that the library agrees with what you're saying there and that it's practical on a day-to-day basis. But overall, good job, and more discussion to follow.
Yeah, thank you for some of those comments about the finer points within the code. Alderman Parrish, I think that attorney's update is tended to focus more on the legal aspects, but there are some of those, we talked about that the other week in the staff meeting, where there's like the top 5 or 6 small things that have been sitting on the back burner for a while that are going to get wrapped into this as we go. They weren't ready for tonight, but we're going to put them in there as it progresses to planning commission, and then it'll go through them and then come back through us again. This is more of just the appetizer. We'll have the full meal another night.
Right. Yeah. Effectively, we wanted to just make it clear that these are the changes related to Reed and the case law, and then to bring policy into the discussion afterwards, so that we knew that we were looking at changes for 2 different reasons. So just to clarify it.
Alderman Tlaco.
Would you be able to give me the background about the blue signs and how those came about?
Yes, effectively.
Do we have 3 hours?
Yeah, I mean, as quickly as I can. The proposed sign code as it related to public properties and right-of-way at the time it was adopted did not allow for any of those types of directional signage that you would typically see. There were a couple property owners that came forward and objected to that they felt that it was a fairly critical component to their operations to have those types of signs, and there were enough council members that were sympathetic to that plight that they wanted to include those signs, or at least the opportunity for those signs within the code. Now, with that said, we did, in an attempt to try to minimize it as much as we could, put restrictions on it related to, you could only have one within, so many feet, within the roadway. We limited it to certain roadways, not all roadways, those types of things. But it was designed really to address the concerns of some business owners that had come forward and said that they really felt they needed to have that sign.
Yeah, we had a long-standing tradition of having a few blue signs throughout the city with no real solidly documented process. And then Reed basically said, well, you can't call that a directional sign because you're telling us, by the fact that you are telling me it's a directional sign, you made a determination about it. You're using your judgment to say that's needed, but this other sign isn't. So that was where we were potentially getting into a little trouble legally with Supreme Court decisions that were coming down. So we tried to address that as best we could without prohibiting them outright. But maybe we can make a small tweak now to perhaps contain them more, but it nonetheless remains an option for people.
Yeah, my only comment pertaining to the blue sign is that you did it by Villa Grove Park. I think it's actually been useful because it grabs people's attention. Google Map has it at a different address than what it is, so people see that sign. So I do see some of it being useful for maybe harder to find businesses. And
that's our
parks.
park, so we can probably put it there, but it's really, yeah, it's maybe harder to find businesses that are in the more rural parts of the city, or right. Trinity Lutheran Church, for example, I think has 1 or 2. Alderman Bach.
Just a quick question. By rolling the dice on the gas station electronic signs. There's no intent there to open up electronic signs for more businesses, or the goal is to keep electronic signs out?
That would be my recommendation, I think, just based on the longstanding policy of the city, to basically discourage those signs. And I think that, as I say, really we'd try to classify those signs more in a purely informational kind of category, as opposed to pure commercial, to try to address some of that risk. But there is some risk. But as I said, it's the one that I don't know that there's a good answer to, because it's such a critical component of what we all, I think, envision gas stations to be. So it's one of those that the courts give us, hey, here's this great decision, and they don't necessarily think it all the way through about what it means for every instance, because it's not necessarily the question immediately before them. So
Supreme Court justices don't fill their own cars. Got people for that. Any further comments or questions? It's a good discussion. I think if it stimulates thought, there's time to email it into the attorney or Director Tollefson as we go through this process. I'm sure as everyone goes home tonight and continues to think about it, ideas will continue to come forth about specific policy things, in addition to the legal aspects that we could put forth, and wrap this all up in one measure while we're working on it. So if there's no more questions or comments, checking around, I'm not seeing any, we can move on to reviewing our future policy items, or the Committee of the Whole planning calendar and any potential future items. That is on page 65 and 66 of the packet. So next month, we're looking forward, we have TID 4 and 5 streetscape zoning and incentives, and then community development operational analysis. So it'll be the community development show next month. And if there's any other ideas, we can bring them forth here. Alderman Bach is raising his hand.
Yeah, I have one potential that I've talked with Director Tollefson a little bit about, from a resident on the bluff on Lakeshore Drive, with a new addition of the Vermont Park steps. There's been requests from at least one resident to do something similar. And so we got into this whole discussion about structures, and Director Tollefson, in discussions with me, suggested this might be a good place to kind of have a discussion about that. The resident was going to put a formal request in writing. Super nice guy, just wants to kind of open the discussion. So that's a suggestion.
Was there we're going into a period where construction is not likely to occur. Is this something we could maybe get to early in 2024? I know there's a little more flexibility in that calendar, a little bit farther we move out. Administrator Jones is shaking his head yes. So we'll look at a spot to get that in there. I think that'd be a good topic to discuss. Thank you. Anyone else? Seeing none, is there a motion to adjourn?
Move to adjourn.
Motion and a second. All those in favor, please say aye.
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 Any opposed? We're adjourned from